Today's lecture will be on Chapter 4. You might want to pull up the PowerPoint. I have posted it. Sorry about last week where I posted it on Friday. I just forgot to do that. I'm beginning on page 95 of your textbook of edition 5 of the book if you want to follow along. The lecture will cover the court system and cases. So let's begin. The first subject in the chapter, I'm on page 95, is jurisdiction. Okay, now what is jurisdiction? Jurisdiction is all about the power or the authority of the court to hear a particular case. The first topic they talk about is what they call geographic jurisdiction, and I don't like that discussion. Okay, we have another word for that in the law. It's called venue. Okay. Venue is about the proper place geographically where to file a lawsuit. For example, let's say my wife and I were getting divorced. Okay, proper venue would be in the Superior Court of the County of Kern because that is where we both live. It would not be the Superior Court of Montana, okay, because neither one of us live there, neither one of us have property there. Our children were raised here, things like that. I still have a minor son. So the venue would not be proper. Okay, it also wouldn't be proper in Los Angeles Superior Court. Okay, now the difference between jurisdiction and venue is this. Let's say I sue my wife in Los Angeles Superior Court and the case goes all the way to judgment. That judgment would be valid. The Superior Court of Los Angeles would be able to hear the case because we are both California residents. Okay, so the judgment would be good. Now let's take jurisdiction as opposed to venue. Okay. By the way, the Superior Court of Los Angeles wouldn't hear the case. They would say, listen, you guys are both from Kern County. What are you doing? And the judge would say, what are you doing in my courtroom? And he would transfer it up here to Kern County. Okay, because the taxpayers of Los Angeles don't want to waste their money hearing a divorce case between two people from Kern County. So that's venue. Now jurisdiction. Jurisdiction, I said, is about all the power or the authority of the court to hear the case. And the reason jurisdiction is so important is because if a court doesn't have jurisdiction, the judgment in the case is not enforceable. It's subject to what we call a collateral attack because the court didn't have the power to hear the particular case. The first type of jurisdiction the book talks about is subject matter jurisdiction. Subject matter jurisdiction has to do with the power of the court to hear a particular type of case. And it's extremely important in federal court. The reason is because federal courts are courts of limited jurisdiction. And what that means is they can only hear cases that the Constitution or federal law allows them to hear. Okay? Jurisdiction is so important in federal court that when you file a complaint, which is a document that initiates a lawsuit when you sue somebody, the basis for the federal court jurisdiction must be stated on the first page of the complaint and in the first paragraph of the complaint. Similar to the concept of subject matter jurisdiction is the concept of exclusive jurisdiction. Okay, there are certain matters that can only be heard in federal court. Okay, for example, bankruptcy matters, copyright and patent matters, matters that occur under maritime law, which let's say we got in a boat accident in the ocean, things like that. That only those cases can be brought in federal court, which means you cannot bring them in state court. The most important type of jurisdiction is what we call in personam jurisdiction. Okay, subject matter is about whether the court can hear that type of case. In personam or personal jurisdiction is about whether the court has power over the parties in the case. Okay, let me give you an example. let's say I'm in a contract dispute with, I don't know, somebody that sold me a car. Okay, and, I think they committed fraud on me or whatever it might be. Okay, I can sue them. The proper venue, if we were both here in Kern County, would be Kern County, because we're both Kern County residents. Normally we go by the defendant's residence, or where the contract was formed, which would have been here in Kern County. So venue would be here in Kern County. Okay, the court would also have personal jurisdiction over the defendant because he's a resident of Kern County, and also he transacted business here in Kern County. So the court, this Kern County Superior Court, would have personal jurisdiction over the defendant. Okay. Now, let's say I wanted to sue him in Mongolia. Why? Well, I've always wanted to see the yaks in Mongolia, and I think it would be cool, and I think the courts of Mongolia are particularly fair. And I went to Mongolia, and I got a judgment against the defendant that I sued. And now I come to California and try to enforce that, maybe by garnishing his wages, putting a lien on his property, whatever way I want to enforce the judgment. Okay. The court in Kern County, if the defendant objections, would not enforce the judgment against him. Why? Would it be fair to sue him in Mongolia? Well, the answer, of course, would be no. Okay, the contract was not executed or performed in Mongolia. The defendant doesn't have any contacts with Mongolia, and so it simply would not be fair to sue him in Mongolia. And so he could what we call collaterally attack the judgment, and the court in Kern County, or any court in the United States, would not enforce the judgment. Okay, personal jurisdiction. It's a really difficult concept. And in fact, in law school, in civil procedure, we spend the entire first month just on this concept. It's all about fairness. If you're all concerned about jurisdiction, just ask yourself this question. Is it fair for me as a plaintiff to sue the defendant in this particular court? Generally, now it's a little more complex than this. Believe me, we spent a month on it in law school. But if it was fair to sue him, generally we'll be able to sue him. Okay, so that's why jurisdiction is important, because if you don't have jurisdiction and you get a judgment, you have nothing but a piece of paper. The other types of jurisdiction that are highlighted in your book really aren't that important for our purposes. Okay, in rem jurisdiction is jurisdiction over property. Okay, so let's say the defendant lived in Maine, and you own a piece of property here in Bakersfield. Well, I could obtain in rem jurisdiction because he has property located in the state. It's a complex concept. I don't want to get into that. Hierarchical jurisdiction really has to do with which court in the hierarchy of the court system has power to hear the case. For example, the trial courts are what we call courts of original jurisdiction. And then once the trial court renders his judgment, then an appellate court would have jurisdiction to hear that case, but not until then. Okay. The last type of jurisdiction I want to talk about has to do with federal courts. Remember, I told you federal courts are courts of limited jurisdiction. Okay. There are certain times when federal courts can hear matters of state law. The most common one, and it's not in your book, so I won't test you on it, is the concept of what we call diversity jurisdiction. If two litigants are members of different states or citizens or residents of different states, and the amount in controversy, I believe it's $75,000 or more right now, you can sue someone under state law in federal court under diversity jurisdiction. And in that situation, the court will apply state law. I don't want to really get into that. I'm just trying to be consistent in making you aware of the concept of jurisdiction and make you aware of the fact that sometimes you can see state law claims in federal court under what we call diversity jurisdiction. Now let's talk about the courts. Okay. At the lowest level is the trial court. The trial court's job in a case is to hear testimony and evidence, whether in the form of its documents or witness testimony, whatever, and decide issues of fact. If we have a jury trial, the jury gets to decide the issues of fact, and then the judge gets to decide issues of law. If we have a bench trial with no jury, the judge gets to decide the issues of fact and the issues of law. After all the evidence is in, the jury or the judge will decide who's more believable or who should win, and a judgment will be rendered. Okay. If a judgment is rendered and we don't like the decision or disagree with the decision, we can take our case to the appellate court. In the vast majority of instances, you have an automatic right to at least one appeal. The appeals are heard by appellate courts, and we'll get into the different appellate courts in federal and state in a minute. Now, this is extremely important that you understand this. The question that the appellate court, which is going to be a 3-judge panel, is going to decide is this: did the judge screw up in applying the law to the case? It is not the role of the appellate courts to go back and try issues of fact. Okay, let me give you an example. Let's say I'm involved in an automobile accident, and I sue the person that I think is at fault. I have 10 witnesses who say the defendant ran the red light. Let's say I've got, I don't know, Pope Francis, Oprah Winfrey, Chief Justice John Roberts of the Supreme Court, and they all say the defendant ran the red light. The defendant testifies that he did not run the red light, and the one witness that he brings in is the passenger of his vehicle, who's his crack whore girlfriend, who was high at the time of the accident. And the jury decides to believe the defendant's girlfriend and not my witnesses. On appeal, it is not the appellate court's role to decide the question of fact again. Why? Because the jury got to hear the evidence, and the jury got to see the demeanor of the witnesses. And if they choose to believe the defendant's crack whore girlfriend over Oprah Winfrey and Pope Francis, that is their prerogative. So you can't go up there and say to the appellate court, listen, look at my witnesses and look at their witnesses, and obviously their witnesses are lying. That's not their role. What their role is to determine if the judge screwed up. For example, if the judge didn't let my witnesses testify, that would be an error of law. If the judge misapplied the law to the facts of the case, that would be an issue on appeal. But it's not to retry the evidence, unless there are specific exceptions, like in a few criminal law cases, but there's so few, they're almost irrelevant. Okay. Normally, if you win in the appellate court, what happens is the case is remanded to the trial court, which means you get a second bite at the apple. You get a shot at retrying the case, okay? Rarely on appeal does it mean the case is over. It just means it goes down to the trial court for a retrial with instructions from the appellate court. Okay. The final hierarchy in the court system is the Supreme Court. Okay, in California, we have a Supreme Court. At the national level, we have the U.S. Supreme Court. Okay, the Supreme Court of the United States and the California State Supreme Court, you do not have an automatic right to appeal. If you want your case heard by them, it's up to them whether they want to take it or not. Okay, there are some exceptions to that. For example, in California, death penalty cases are automatically appealed to the California Supreme Court. But normally, if they don't want to hear your case, they don't have to. Now, how does a case get to be heard by the Supreme Court? Well, what you do in the federal system is you file what's known as a petition for writ of certiorari. And the procedure is that there's a thing called the Rule of Four. And the way the Rule of Four works is that normally the Supreme Court hears what they call the cert petitions on Saturday mornings. And they all get together in a group of 9 and review the certiorari petitions. And if 4 of them vote to hear the case, it gets put on the calendar for briefing by the parties and oral argument. One small final nuance on it is sometimes the case can go from a state Supreme Court to the federal Supreme Court, but those circumstances are rare. They usually involve cases involving constitutional criminal law, but it can happen. So now let's talk about the court structure itself. Okay. In the federal system, at the top is the United States Supreme Court. There are 9 members of the court. Okay, as I've said before, they're appointed by the president and confirmed by the Senate. Okay. Below the United States Supreme Court is the United States Circuit Court of Appeals, and there are 11 judicial districts. I believe there is a map in your book with the districts. Let me see if I can find the exact page. Yes, it's on page 96, and there are 11 circuit courts. Okay, California is in the 9th Circuit Court of Appeals, which is the largest of all the districts. It actually used to be larger before they created the 10th. When you go to an appellate court, you get a 3-justice panel to hear your case. At the trial level in the federal court system, we call them the United States District Courts. These are the trial courts. Most states only have 1 United States District Court. California has 4. Okay, doesn't mean we have 4 courtrooms. We have 4 different districts. Okay, the Southern District encompasses San Diego. The Central District encompasses Los Angeles. The Northern District encompasses the San Francisco Bay Area and the coastal areas from about, I think, San Luis Obispo up to the Oregon border. And then the Eastern District is for the Central Valley and the high desert communities like Inyo and Mono County. So if I wanted to file a case in federal court from Bakersfield, I would file it in the Eastern District of California. Their headquarters is in Sacramento. They do, however, have a satellite office in Fresno. I believe they have 3 judges up in Fresno. As of right now, they do not have a court in Bakersfield, with the exception of they do hear some bankruptcy matters in Bakersfield. But criminal trials, things like that, complex civil litigation, that all goes on in Fresno. But the headquarters is in Sacramento. Okay, let's talk now about the California court system. Okay, the California Supreme Court, the highest court is the Supreme Court of California. There are 7 members of the California Supreme Court instead of 9. I guess we're too cheap to pay for 9. And they are located in San Francisco, not in Sacramento. That is also the location of the 9th District Court of Appeals, and actually their courthouses are a block from each other south of Market. Excuse me, my dog is barking and I need to get her out of the room. At the appellate level in California, we have the District Court of Appeals. Okay, do not confuse this with the district courts in the federal system, because those are the trial courts. Okay, we call them the District Courts of Appeal because they're done by districts. Okay, so if you hear someone say the district court or the 5th district, okay, we're usually talking about the Court of Appeals. In Kern County, the State District Court of Appeals is located in Fresno. It's known as the 5th District. and it encompasses Tulare County, Fresno County, uh, Kings County, and Kern County. Okay, and I think there are like 8 or 7 appellate courts. You know, one in San Diego, one in San Francisco, one in L.A., Sacramento. I think there's like 6 or 7. I'm not really sure at the moment. But that's where, if you were in Kern County, you would file your appeal in Fresno. Okay. The trial courts in California are called the superior courts. Now, in the old days, we had a lower version called the municipal courts, but they were done away with over 10 years ago. And the superior courts are done on a county by county basis. Okay, so the Kern County Superior Court is the court in Bakersfield. Okay, they do have some satellite offices, Mojave, Delano, places like that. They used to have one in Taft, but it's only open a couple of days of the week. Okay, in fact, that's where I just got my job, is with the Superior Court of the County of Kern. That's where I'm going to be taking my new job. One other thing you should be aware of if you're reading decisions from other states, they don't always use the same terminology. For example, New York is the exact opposite. In New York, the Superior Court is actually the highest court, and the Supreme Court is the trial courts. Okay, so if you get confused sometimes reading decisions from other jurisdictions, just understand they can have their own terminology, and New York's is pretty much exactly opposite than the rest of the country. Okay, let's talk about judicial opinions a little bit. I think I covered a little bit of this in the first week, but this will be a more detailed discussion. Okay, judicial opinions are basically the written decisions of a court. Almost always it's going to be an appellate court or a Supreme Court. Rarely do trial courts make written decisions that are what we call published and made available for lawyers to rely on and to read. Okay. So what are they for? Well, the basic thing is they're going to inform the parties on who the winner is and who the loser is, and whether the judge screwed up or whether the judge got it right. Okay, they're not real easy to read. My general rule is the older the case, the more difficult it is to read because there's more legal terminology. They're not intended for the general public really to be able to understand them. They're intended to be used for the most part by lawyers so they can understand what the law is, how it was applied, and how it should be used in the future. Okay. I always think the simplest written judicial opinions are the best, but appellate judges, Supreme Court justices, and their law clerks sometimes like to think about how smart they are. Okay, with what I just said, there's one caveat. Okay, one good thing about modern opinions is they generally follow a format that is familiar. That's one way to put it, which is the IRAC format. They're going to have first of all, a summary of the case. They're going to have the issue. They're going to tell you what the law is. They're going to apply the law to the facts, and they're going to come to a conclusion. That's IRAC, and that's what we do when we brief cases. Older cases generally don't, a lot of times, follow that format. Okay, so they can be, even though they might be a little less sophisticated, they can be a little bit more difficult to read because of the fact that there's no rule about how a judge has to write an opinion. They can write it literally in any way they want. Okay? There's no set format that they have to follow when they're writing an opinion. And judges are just like any other individuals. They have their own style and way of doing things. Okay? Unfortunately, this doesn't make it easier for the rest of us. So now let's look at a court opinion. I'm on page 104 of the text. If you have a different earlier edition of the book, I'm sure there'll be one somewhere in this chapter as well. The case is DiPierre versus the United States. It was argued before the Supreme Court. I know that because at the top of the page it says Supreme Court of the United States. on February 28, 2011, and decided on June 9th. Okay, this is quite common that it's months later after oral argument, because the judges have to write it up and decide who's going to write it and decide if they want to join the opinion and all that. Normally, the Supreme Court of the United States cases come out over the summer, about 2 or 3 a day. Okay, so if you're looking at this version, okay, this is a version, the West version of the Supreme Court. Okay, they have actually 3 different what we call reporters, and reporters contain the cases decided by the court or any court. And these cases are put into volumes that we call reporters. And there's the Supreme Court reporter, there's the official United States Supreme Court, and then there's the West version. Okay, there's 3 different volumes. And the official version that the Supreme Court puts out itself is always slower than the paid prescription ones like Westlaw. Okay, so the caption shows the names of the parties. After that, you're going to see a background. Okay, now important. The background and everything you see written until you get to page 106 in your book, and where it says Justice Sotomayor delivered the opinion of the court. Everything you see before that, the background, the syllabus, which is a summary of the case, the keynotes that cover the different points of law in the case, that is all written by somebody at West. It is not officially part of the case. You can never cite a syllabus or a head note when you are citing authority to a court. You must go to the actual body of the opinion and cite the opinion itself. Why? The judge did not write this stuff, so it is not the law. And sometimes it is wrong. Not very often, but sometimes it is. So never quote from a syllabus, which is the summary of the case, or a head note, which are those little things with the little key numbers that break down the issues and the law in the case. I hope I got my point across. So the case actually begins on at the kind of the second column, halfway down on page 106, where Justice Sotomayor delivers the opinion of the court. Everything after that is the law. Okay, the main parts of an opinion. Remember, they do not have to be in this order. Okay, but they are normally will start with a summary of the facts. They will also usually include a procedural history of the case, which means how it got to the Supreme Court or the Court of Appeals or whatever it is. Then they will have a holding, which is like their conclusion. Sometimes they can put this at the end, but they can usually put it there, saying what they decided. Okay, that's the holding or the ruling of the court. And then they'll have an explanation as to why they decided the way they did. Okay, the holding can contain the conclusion and possibly the rule of law used. Okay, but remember, the judges are free to write it in any way they see fit. So you will not always see it in this nice, simple format. At the end of the case, you'll normally see which judges join the particular decision, although that's not always true. I don't think in this case, I'm looking on page 114. I don't see which judges joined. Maybe they abstracted that out, but if we have the full case there, I know they took part of it out because there are the ... dots there on page 116, or I'm sorry, 114. And then after you find out which judges have joined, along with Justice Sotomayor's opinion, remember the justices are free to write a concurring opinion or a dissenting opinion. In this particular case, Justice Scalia has concurred in part, and concurred in the judgment, which means there are probably a few things that he disagrees with Sotomayor, but he agrees with the result. He's just getting there a little bit different. Okay, if judges totally disagree, they can write a dissent. Okay, warning, I've told you this before. You cannot quote a dissent because it is not the law, unless you're arguing to change the law. Good luck with that. Okay, so let's go. I'm on slide 12 of the PowerPoint if you're keeping up. Why do we research cases? Well, that's where we find the law. And then what do we do with that? We use that law to assess our client's situation and build an argument that will help them win. Or if the case hurts our client, find ways to distinguish that and convince the court that they shouldn't follow the law articulated in this particular case. Okay, now let's talk about briefing cases. First, why do we brief cases? Okay, well, there's a couple of reasons. One reason is because, believe me, you're not going to be able to keep everything in an opinion in your head when you go to write something up. So what a brief does, it gives us like a page summary of a case with its essential elements. We're just boiling it down to its main points, so we can use that when we're preparing our arguments or whatever we're ever using it for. Okay. The reason you would be briefing cases is to give your attorneys a short summary of what a case means and its significance. Now, in law school, and this is for those of you who are thinking about going to law school, the thing we do every day is brief cases. And in law school textbooks, you don't have the nice summary of the case and the key numbers and the summaries of all the issues and all that. You just get excerpts from the case itself, and you have to brief it from scratch. Now, why do they do that? Because the best way to learn to think like a lawyer and develop those analytical skills is by briefing cases. Now, if you go to law school, believe me, every case that you read in the case books, the textbooks that you use, there's going to be what we call commercial or canned briefs, where they will actually do the briefs for you, and you can buy them. They sell them in the bookstore. Do not, I repeat, do not use canned briefs. And this is why. One, if your professor finds out you're using canned briefs, he will become livid and he will torture you for the rest of the semester. The reason he will do that is because you're lazy and you're not learning to think for yourself. The people that, in my opinion, that do not pass the bar exam are the people that do not take the time to do their case briefing themselves. Now, everybody has their own style. In my first year of law school, I religiously briefed all my cases, hand wrote them out or typed them out, and had them prepared for class. One of the reasons you have to have those ready for class is because professors call on you, and they're going to say, Mr. Jameson, what's the issue? Or what was the court's holding in this case? And you've got the brief right there, and if you've done it right, you'll have it. Now, sometimes you'll be completely off, okay? But that's okay. At least you went through the process. Believe me, you're not going to get every case brief right if you do them by hand. And it's something you get better with. As you get farther in your law school career, you can do what's called book briefing. And I did this pretty much my second year and my third year, which was this. I would actually just open the book, I would highlight the stuff, and in the margins I'd write I for issue, or F for facts, or C for conclusion or holding, H for holding, whatever you want to use, A for application. So I could quickly refer to the text to do that. And when you go to study for finals, the easiest way to remind yourself of what happened in the cases is to go back to your case briefs. Okay, so if you want to use canned commercial briefs, go ahead. Good luck on the bar exam. Okay, so how do we start a case brief? Normally we'll start with a correct, what they call a correct case citation. We haven't talked about correct citation yet, so I won't really get into it. I'll just explain it briefly. Okay, normally what it'll do, it'll have the name of the case, you know, Jameson versus Jones or whatever, okay? And then it'll have a number, like 1 or 500, whatever it is. And then it'll have the reporter, okay? So for example, in California, for the appellate court, it's called CalApp. So it'll say something like 1 CalApp 4th, which means the 4th edition of CalApp. And then it'll have like 228. So what that means is it's the first edition of the California Appellate Reports 4th series, beginning on whatever page, 222. Okay, so I'm not worried about citation yet. Believe me, we'll cover it later in the course. Okay, I'll teach you how to read citations and find things. We're not there yet. Okay, then we will have a short summary of the facts. Okay, if you go to a West or a Lexis edition of the case, they will have that. You'll find that in the syllabus, the summary of the case. A lot of professors like the procedural history of the case. I'm not big on that. I don't mind if you don't put the procedural history in the case. The only time I really deem it important is if it's something significant, or actually the case deals with an issue of like civil procedure or criminal procedure. But normally that's just a history of how it got to the particular court that is deciding the case. Okay, so we're going to have, it's IRAC, issue, rule, application, conclusion, but I wouldn't, you'd think of it as FIRAC, which is facts, issue, application, conclusion. Okay, what's the issue? The issue is whatever the court thinks it's deciding. You know, can a high school student wear a t-shirt that says fuck on it to school? Or does that violate his free speech under the Constitution and the First Amendment? Who knows? Okay, stating the issue is important. Okay, in fact, how you state the issue almost always for a court determines the outcome of the case. And the Supreme Court are brilliant at this. And let me give you an example. In the case of Bowers versus Hardwick, a case decided in the 1970s, a young man was having sexual relations with another young man in his bedroom. The cops in Georgia busted in because they were executing a search warrant, and they catch the defendant in the act of having sexual intercourse with his friend. He's brought up on charges in Georgia because at that time sodomy is illegal in the state of Georgia. Okay. In that particular case, Justice White, who was a great judge in my opinion, but he was a product of his times, he stated the issue as whether the state of Georgia could outlaw sodomy. And the Supreme Court, in my opinion, one of the worst decisions of all time, and maybe it's in the top 10, sided with the state of Georgia and said it was constitutionally permissible for Georgia to outlaw sodomy. Now, interestingly, in this case, the sodomy laws, which, if you don't know, are oral and anal sex, the sodomy laws applied equally to men and women as it did to homosexuals. And there was not even an exception for people who were married. So, if you state the issue in a different matter, you can come to another conclusion. Because what if the issue had been, can a state government prevent a married husband and wife from engaging in oral sex in the privacy of their own bedroom? Believe me, if you state that as the issue, you're going in your mind to come to a different result. At least you should, in my opinion. I just personally don't think what I do in my bedroom with my wife is anybody's business, as long as we're both agreeing to it. So you can see how stating the issue can a lot of times foreordain the result. Fortunately, Justice Kennedy and the court, in a decision written by Justice Kennedy about 10 years ago, struck down Bowers versus Hardwick. And the law of the land is do whatever the hell if you want if you're two adults in your own bedroom. God bless America. Okay, so normally after the facts, when you draft a case brief, you're going to state the issue. Okay, sometimes it's hard to find, sometimes you won't figure it out, sometimes you'll get it wrong, but don't worry. I want you to go through the process. If you get it wrong, don't worry. I'm not going to mark you down. Okay, so you have the issue, and then after that, the court will usually put the holding, but I want that at the end. Okay, then what we will have, IR rule. You need to find the rule of law. Every case will have a rule of law in there. Okay, sometimes it's hard to find, but it will be in there. Then we will have the application or the analysis section. This is where the judge takes the facts, applies it to the rule, and that is the analysis. Okay, now this is the thing. Sometimes the analysis will be really detailed, and sometimes it'll be really vague and sketchy, depending on the intellect of the judge, or whether, there's all kinds of reasons that their application or their analysis can be sketchy. Okay, sometimes they do it intentionally, sometimes they just don't bother to do it. Okay, all right. After the application of the law to the facts, there will there'll be some conclusion. Okay, now sometimes the conclusion is just the plaintiff wins because of this. Other times we can call this conclusion a holding. And the holding usually is the new law that is announced in the case. Okay, so the holding will basically, don't confuse sometimes the rule of law that they apply to the holding. Because sometimes they'll just apply an old law, say how it doesn't work, and enunciate a new law in the case. Okay? And that's usually the kind of cases we read, because this is what we would call the landmark case, or the most recent case, whatever you want to call it, that contains the newest, freshest edition of the law. The PowerPoints also talk about the reasoning. Okay, you don't need a reasoning section. That should be in your analysis. And the disposition. Okay, you don't need the disposition. You can include that in your conclusion, but the decision is usually something like affirmed, which means the judge didn't screw up below. Reversed, meaning the judge did screw up, and we're going to send it back down for retrial. Vacated, which means they're going to basically just be disposed, the case is going to be disposed with, etc. Okay, so that's it for a brief. Okay, I'm going to have you brief 2 Supreme Court cases this week. Okay, they're difficult, but they are cases that you should be able to find the head notes in the syllabus to. If you can't, that's even better, because I recommend that you try this stuff without using the cheat sheets, meaning finding a canned brief or using the syllabus and the keynotes, okay, which are the brief summaries of what the case is about. Okay, there are reasons those keynotes are out there. It makes our legal research later or easier down the road. Okay, so have fun with it this week. Don't worry about the format or whether you get things wrong. Okay. I could have given you Pennoyer versus Neff, which is the first case everybody briefs and everyone gets wrong, which when you go back and read it later as a lawyer, it's just like so simply, it's so easy, it's laughable, but every one of us is terrified in civil procedure our first day when we have to discuss Pennoyer versus Neff. If you want to know, holding that case is basically, if you're in a state and they slap you with papers, the court has jurisdiction over you. But it's a 120-year-old case, and it's written a way that law students, when they first get into law school, can't understand it. All right, that's it. Okay, I think case briefing actually is so important. I'm going to have you do one every week. I'm sure you're all looking forward to that. But understand, they won't be as hard as the ones this week. They'll be easy, and then I will have little video discussions on each and every case. They'll be pertaining to California law. Have a great day. Have a great week. Over and out.